Hi. Most of you must have heard by now that the 2023 IT Rules Amendment petition came in a split verdict. I just wanted to make a video about why comedians and some journalistic organizations are in the Bombay High Court and what IT rules are being talked about, because this petition centered around a rather important cause: free speech on the internet. Hold up. Attention retain karne ki ninja technique. To start with, in 2021, Sarkar introduced Information Technology Intermediary Guidelines and Digital Media Ethics Code rules. According to the press release by the government, they were made to empower the ordinary users of digital platforms to command accountability in case of infringement of their rights. Now, these rules and its amendments have been in the news for being restrictive, and the Internet Freedom Foundation has done detailed pieces about the problems with these rules and their amendments, such as excessive controls over digital media news and so on. They've also challenged these rules before various high courts. The amendment that's important to our story is the one made in 2023 in an attempt to combat the problem of fake news on the internet. The Kendriya Sarkar wants to set up a fact-check unit run by the government, and more on this very soon. Now, the petitioners found out about this with the rest of the country and contacted their lawyers, and long story short said,
सुनना मैटर हो गया है आओगे
and filed a writ petition before the Bombay High Court challenging the constitutionality of the 2023 amendment. The Editors Guild of India and the Association of Indian Magazines also filed their petitions regarding the same laws. The EGI works towards protecting the freedom of the press, and the AIM is an industry representation of magazines. I should tell you that the Internet Freedom Foundation's litigation team was a part of the effort to represent the AIM, and I reached out to them to review this script before I recorded this video. So, what is the tea? Rule 31B says that a significant social media intermediary like Facebook, Instagram, or YouTube must make a reasonable effort to ensure that certain kinds of content are not available on their platforms. Like, for example, pedophilic content or posts promoting enmity between religions. If an intermediary fails to make reasonable effort to avoid hosting or transmitting such content, then they will also be liable for the content posted by their user. The amendment, among other things, adds the words by itself and to cause the users of its computer resource to not host to this Rule 31B. And it changes Rule 31B5 to include the words or in respect of any business of the central government is identified as fake, false, or misleading by such a fact-check unit of the central government as the ministry may by notification published in the official gazette specify. Net effect, if the fact-check unit identifies such content and then notifies the intermediaries कि हमने fake news identify किया है, and if they do not make a reasonable effort by itself to not host, display, upload, modify, publish, transmit, store, update, or share such content, then they could be looking at a legal penalty. Usually, under Section 79, the intermediaries are not penalized for how their users use their platforms. This is called a safe harbor provision, which protects them from the actions of a third party, that is, any user of their platform. But if they continue to host content that is prohibited, the government takes this safe harbor away. Now, fake news is to be one such ground. Fake news ko fake kaun declare karega? The answer is Sarkar through the FCU. So Kunal Kamra, EGI and AIM's petitions say that this is kind of cringe in the sense that this is not exactly constitutional under Article 14, 19 and 21. The contention of the petitioners is that they will make the government a final authority on what is the truth, which is dangerous for dissenters and journalists who are likely to contradict the government's claims. Along with that, it incentivizes the intermediaries to comply with the fact-check unit in a way that harms freedom of its citizens to use digital media to express themselves. They've also stated that terms fake news or fake, false and misleading and even business of the central government are vague and overbroad to the point that they can be made to mean whatever you want them to. The government disagrees, saying that the FCU has no authority to order a takedown of content. All takedowns have to follow the same procedure under Section 79(3)(b and the IT blocking rules, which are entirely different rules than the one we're talking about. And that the dictionary meaning of the words fake, false, and misleading are enough to understand what is meant in the provision. The government has also said that only the business of the central government will be checked by the FCU. I should tell you that this is a summary of days of arguments, and I have the runtime of this video to summarize them. And at the end of these arguments, the two judges have come to two opposite conclusions. Justice Dr. Gokhale said that fake news is a serious and growing problem, and the government is right. The FCU would help combat it. She says that satire and comedy are not the target content for the application of this provision. All content about the business of the government is. And one can always file an appeal with the Grievance Redressal Committee or the courts against any blocking of the content. Her judgment also mentions that the vagueness of certain provision cannot mean it's unconstitutional. Now, the other judge, Justice Patel, has agreed that fake news is a serious and growing problem, but the fact-checking unit seems to appoint itself as an authority on what is truth and will also create a legal system that will incentivize the intermediaries to potentially restrict content in compliance instead of due process. His judgment says that words like fake, false, and misleading are vague enough in their scope for the amendment to be unconstitutional, as this affects free speech under Article 19(1)(8) directly. Also, I don't need to, but I will mention this. Justice Patel's judgment also says that nobody wants a fifth Matrix movie. Now, why do you care about this? It's because the AI meme revolution is here, and it is easier than you think to restrict some of this content. Of course, a lot of it is tonally just gives it away that it's a joke, but the deadpanness of a joke translating into a takedown order or second guessing every content idea because it might get flagged for misinformation is by itself a completely avoidable problem. And then the government can hold Instagram responsible, which means they will take down the content just to be safe. This can have highly worrying effects on what information survives the purge also. Not giving this much power over information and speech is something that we owe ourselves as the citizens of this country. Right now, this litigation is important, and I'm happy to make these not so short videos to keep you updated about cases like this. The petition will be heard by a third judge now, and I'm certain we will provide you updates on that as well. If you want to support work on these litigations, consider donating to the Internet Freedom Foundations. They do public consultation on legislation and commit their resources to advocate for your digital rights, and with participating in litigations like this and help generate content like this. So,